We're now in week 2, which means that we're on chapter 3 of the reading. And chapter 3 of the text starts out with a discussion of institutional patterns of justice in relation to defined rules. And the text gives us examples of definitional law, substantive law, procedural law, and politicality. But for our purposes, the focus is going to be on substantive versus procedural law. And that distinction is really important because before any society can implement a successful criminal justice system, you must have defined rules, which is the substantive law piece. And you need to figure out how those rules will be enforced, which is procedural law. So basically, substantive law deals with a citizen's legal obligations, the part of the law that creates, defines, and regulates rights. More concretely, examples of substantive law would be things like the statutory definitions of crimes that are found in the criminal codes. Substantive law serves two purposes. First, it defines the behavior that is subject to punishment, and second, it specifies what that punishment will be. Now, procedural law are the procedures or guidelines that tell the government officials how to interact with citizens. So, for example, case law like Terry stops and Miranda warnings. Now, the text talks about the 4 general features of Western criminal law: politicality, penal sanction, uniformity, and specificity. Now, politicality basically is only violations of rules that are made by the government can be crimes. So a homeowners association can make regulations, but violating them isn't going to be criminal. Same with rules that a teacher may have in a high school classroom, things like that. Now, penal sanctions, to qualify as criminal law, there must be punishment for violation of the rule or law, and that's what they mean when they're talking about sanctions. Uniformity basically says that criminal liability should be the same for everyone, despite social status or background. And then specificity, people need to know in advance what they need to do or what they need to avoid doing. So basically, they have to have notice of the specific rules. So those are the things that are required for a crime to be a crime. But how do we decide whether certain behaviors are actually criminal? Now, Jerome Hall suggests 7 criteria must be present: mens rea, actus reus, concurrence, harm, causation, punishment, and legality. Now, mens rea is basically just somebody must have the requisite frame of mind to commit the offense. And then actus reus means a person must actually take some action. Bad intentions are not generally enough. So you can think about killing someone, but once you actually take a step to do that, like hiring someone, you cross the line. No, concurrence is just a fusion of the intent and the conduct, and the rest are fairly self-explanatory, but obviously reach out if you have any questions. Now, the weird exception to this is strict liability crimes, where the person is considered responsible despite their intent. Now, a good example of that is felony murder, which we have here in Arizona, and that was discussed in the book. So, for example, if you have a robbery case, 2 guys go in to rob a Circle K. One of them pulls out a gun and shoots the clerk. The other guy, the one without the gun, may not have intended for anyone to get shot, but he's still likely going to be charged with felony murder. Now, same situation, but it's the clerk that pulls out the gun and shoots one of the suspects. Now, the other suspect could also be charged with felony murder if the suspect that was shot dies. And there are also recognized defenses based on the absence of criminal intent, and this typically varies from state to state. Our textbook focuses on insanity, which has been defined differently both over time and again from state to state. The 13th century was the wild beast test, essentially saying that someone was so close to being an animal that they were lacking in reason. And then in 1843, we had the McNaughton test, And in that case, the defendant, McNaughton, was found not guilty of murdering the victim, Edward Drummond, because McNaughton was having delusions at the time of the murder. The public was totally outraged by this, and as a result, the McNaughton rule was developed. And essentially, what that rule is it's a right from wrong test where to be insane, it has to be shown that at the time of the crime, the defendant was operating under a defective reason so that he was unable to know the nature of quality of the act. And two, if the defendant was aware of the act, he didn't know it was wrong. And there have been other variations since then, and some states have abolished insanity altogether. Here in Arizona, we have guilty but insane, and that's an affirmative defense, so defendants are actually required to prove that. Okay, so let's talk about procedural law in more detail. And it's important to note here that while the U.S. Supreme Court can tell states how to proceed when the state seeks to deprive citizens of life, liberty, or property, they cannot tell individual states how to conduct the criminal prosecutions. Now, under the procedural law category, the text discusses two models, the crime control model and the due process model. And we'll go to the crime control model first. Characteristics include administrative emphasis, emphasis on finality, and the presumption of guilt. So even though we're saying presumption of guilt, it would still be treating suspects as if guilt remains an open question. It's just, in a way, kind of leaning more towards that initially. Now, to operate successfully, a crime control model requires high rates of apprehension and conviction. Now, the due process model emphasizes efficiency, legitimacy, and individual rights. So, versus speed and finality, which the due process model actually sees as an invitation for abuse of government power. Now, the due process model distinguishes between legal and factual guilt. And what I mean when I'm talking about that is factual guilt is when someone is clearly, by the facts, somebody that committed a crime. So the person admitted, they were seen committing the offense, things like that. Now, legal guilt would be somebody that committed the crime or is factually guilty, but is legally found not guilty due to exclusion of evidence or some other kind of technical rule. Now, and I'm sorry, I'm having some allergy issues, so bear with me. To give a more concrete example of procedural and substantive law, the book looks at the USA Patriot Act, which has now been largely replaced with the USA Freedom Act. And there's a required reading material on that in BB Learn, just so you have the update from when the book was written. But specifically, the book focuses on a couple sections of the Act to prove points and to get discussion going. So, first, the roving wiretaps. Section 206 of the USA Patriot Act allowed for court wiretaps, for court wiretap orders to specify a person rather than a certain phone line. And the purpose here was to aid spy and anti-terrorism investigations, but critics were really concerned about interception of innocent parties' phone calls. So that was something that needed to be weighed. Another example provided was Section 213, which was the sneak and peek provision. And that provision authorized delayed notice of the execution of criminal search warrants. And that's notable because it applied not only to terrorism cases, but to any federal cases. Interestingly enough, though, courts had allowed similar delayed notice searches in certain criminal cases beginning as early as the 1980s. So that's not really a new thing. And these types of legislation are not only limited to the United States, especially since 9/11. So, for example, many European countries now allow for extending the length of time government authorities can detain suspects without charging them. So it was kind of an overreaching policy change over multiple nations. So that covers basically Chapter 3. You still need to read it, but that's the overview. And I'll see you guys next week.